I had a decision to make in 2000. I said, I'm getting into my 50s. If I run again in 2004, then by the time I retire, I'm going to be in my 60s. And things that I would have the energy for when I was a kid lawyer, it's going to be almost impossible to tell myself no. And so I just think it's time to serve your time and move on to something else. And as a defense attorney, I think I can make my own unique contribution, and that's what I want to do. But thank you. Thank you.
Well, I'll defer.
You call.
No,
it's
no,
your
no,
class.
Students first, but if there's a gap.
How much harassment did you take for?
We had a.
How much harassment did you take for the court case?
I'm sorry, how much
harassment?
Harassment? For
Joking around, guys giving you a hard time about you being arrested and charged?
Oh, no. The question is, do I still feel any kind of follow-up harassment for having been charged in the federal system? And the answer is no. I mean, there's an organization called the Michigan Trial Attorneys, who are mostly civil lawyers for plaintiffs' cases, and they tell me that my polling numbers throughout the state are still very high. In the courthouse, I mean, even when I was under indictment, judges would call me up and say, "Counsel, I don't believe any of that crap." Okay, I'll step back. Now, and so I've always had. Now, that doesn't mean that. Look, whenever you do something, you've always got to be aware that you create any good that you do creates an enemy. No good deed goes unpunished. So whatever it is you do, you can't say, "Well, I'm doing this good deed, and I'm doing it for all of the right reasons. Yeah, everybody's going to understand." Well, no, it doesn't work that way in real life. And so when you commit yourself to actually do meaningful, good stuff, you actually commit yourself to having a lot of backbiting and hassle and people talking ill of you. And you can either choose to avoid that and live life easily and in kind of a worthless, meaningless manner, or you can go ahead and decide that let them talk about you as long as your conscience is clear and you're doing the right thing. And those are the choices that all of us have in almost everything we do. You can do it the right way and take some grief, or you can take it the easy way, and then when you're 87 and on your deathbed, you say to yourself, how the hell did I miss a meaningful life? Why did I waste all those years just trying to get by instead of trying to do something good? Okay, Professor.
You had a question. Very briefly, you had addressed the culture aspect of the role of the prosecutor, and especially as a head prosecutor, in creating a type of culture in the office and stuff like that. On the other side of it, I've read some literature that suggests some other reforms. Like one article that I'd come across was talking about like a reformation in civil immunity for prosecutors and stuff like that. What are your thoughts on some of the other things, like more like black letter law that can be created, addressed, maybe that can help with this? Because really, when you address the culture of it, that just leaves so much in the hands of individual agency.
Yeah. I'll address your question first on immunity. The whole immunity question arises in this way. A prosecuting attorney met with several different witnesses who are possible defendants, has almost unfettered power to say, I believe you, you, and you, and I want to get that guy. And so you, and you, if you testify the way that I think that you should testify at trial, I'm going to immunize you from criminal liability. You're going to walk, and in exchange, you're going to testify against this person. And there's almost no check and balance on that. The suggestion is made that that power be shared with the judiciary, and that the prosecutor has to, again, my term finder of fact, that there has to be an evidentiary hearing for the prosecutor to justify those immunity decisions. The courts are pretty good in allowing instructions to the jury to let the jury know that the deal has been made and what it means, but you have to go beyond just the jury instructions. You have to have some way to control that at the outset. But there's one other reform, and it sounds so simple, but I think it would be very advantageous, and that is that 12 jurors sit, well, 14 with the 2 alternates, but 12 jurors make a decision. A judge has the power, if the judge believes that the jury verdict is not supported by evidence, well, actually, the standard is that no rational jury could conclude that the person is guilty beyond a reasonable doubt. That's a very high standard. What I would suggest is that in every criminal trial, there will be two separate trials that will be going on at the same time. That the judge makes a decision, first of all, on guilt or innocence, and if the judge believes that the person is guilty, then the case can go to the jury. Basically, in order to not influence the jury, you would have to make this go separately, that you would have the jury make its decision first, and that the judge would have to write findings of fact and conclusions of law. Because I think it's one of the weaknesses I see is that you would like there to be a second trial, but you don't want to take the time for a second trial. In this way, every criminal defendant would have the advantage of both a judge and a jury at the same time. And the judge's decision would have to be supported by findings of fact and conclusions of law. And that would be easier to appeal, because that's the other bugaboo when you take a case up on appeal. If a jury has decided it, an appellate court, the standard language is, we are not going to invade the province of the jury. We don't know why they decided this way, but unless we can show that they had insufficient evidence upon which to base that finding, we are not going to reverse. Whereas if you have findings of fact and conclusions of law, you would have the trial court's decision justified by these reasons, and then on appeal you could attack and you could show this reason wasn't supported, this reason wasn't true, etc. So that's my one quick, easy fix to achieve a smaller additional level of justice. Yep.
Quick follow-up. That was really quite a thunderous answer, actually. that reporter suggested was really cool. In regards to exculpatory evidence, process of discovery and stuff like that, I guess is what I meant to attack more directly within a prosecutor's office. Your office, it seemed, would be like an ideal situation where you told your team, turn everything over, be open, you know, and then we've got things like the Jenks Act or whatever. So what would you suggest? Should every prosecutor's office, for example, have a hard set of you know, 1, 2, 3, 4, 5, this is what you have to turn over, this is when you have to turn over? I mean, that's like virtually impossible, I know, but...
Well, I mean, here's the odd thing about it. Until recently, everybody thought that's exactly what our obligations were. It's only in the last 5 or 6 years that we're getting these instances of holding back. And, you know, I mean, you have a court system, all the courts can do, all the legislature can do is write the laws, the court can come out with their opinion, and then you're kind of like expected to follow it. If you don't, what's the remedy? I mean, that's, you know, you can go back to Plato's Republic, you know, who will watch the watchers? You know, if you don't do what you're supposed to do, well, what's the sanction? And I'm just saying that courts have not been sharp enough in sanctioning prosecutors' offices for not doing it. You actually have to have some cases reversed. I mean, back in the 60s and 70s, now this is going like way the other way, but there were some famous judges in Detroit that would, if the police had treated the defendant poorly, would dismiss. Now that was overkill, because guilty people went free because a judge got offended. However, it did cut down on the instances of police, not only brutality, but impoliteness, because, you know, you don't want to go in front of Justin Rabbits and have your case dismissed. That was going too far. And so I suppose that the answer is that courts have to be more attentive and have some real sanctions again.
So you'd go the route of more like sanctions and stuff, because I think I would more agree with that. I don't know about just removing immunity from prosecutors. I mean, that seems like it would severely hamper things.
Well, I'm not removing it. I'm just saying that there has to be somebody else other than I mean, just look what that means in the average case. You have 4 equally guilty people. Well, nobody's ever equally guilty. You have 4 people. The prosecutor, by himself or herself, locks the door, goes into the room, and decides these 2 are going to go free, and these 2 we're going to convict.